Distinguished colleagues, ladies and gentlemen, it is an honor to have the opportunity to present the findings of Professor Ridwan Khairandy's seminal work titled The Legal Character of Perseroan Companies and the Legal Status of Their Assets, as published in the US Quia Justum Law Journal. This research addresses fundamental legal ambiguities regarding the nature of state-owned enterprises, SOEs, particularly those organized as Perseroan-based, and the status of the assets they possess. Introduction and research objectives. The legal status of assets owned by Perseroan companies has long been debated, especially concerning how state finance is interpreted in various Indonesian statutes. Professor Khairandy's study is normative, based on doctrinal analysis and qualitative legal methods. It seeks to answer two essential questions. 1. What is the legal character of Perseroan companies? 2. What is the legal status of the assets owned by Perseroan companies? Legal character of Perseroan companies. According to Article 1 of Law No. 19 of 2003, a Perseroan is a state-owned enterprise in the form of a limited liability company, PT. This legal form carries several implications that are crucial to our understanding. 1. Private legal entity. Although Perseroan companies are state-owned, they are not public legal entities. They are instead classified as private legal entities governed by private law, specifically Law No. 40 of 2007 on limited liability companies. 2. Separation of assets. A key consequence of being a limited liability company is the legal separation of assets. Once the state invests capital in a Perseroan, that capital becomes the property of the company, not the state. The state is therefore reduced to the position of a shareholder, not an owner of the company's assets. Criteria for BUMN SOE status. For a company to qualify as a BUMN, the state must own at least 51% of the shares through direct participation. If state ownership drops below this threshold, for example in the case of PT Indosat Tbk, the company is no longer classified as a BUMN. Direct participation and risk. The state's direct participation means that it shares in the risks and rewards associated with the company's performance. But, and this is key, only in proportion to its shareholding. Of assets. All assets held by a Perseroan are legally owned by the company itself, not by the state. The only state asset within a Perseroan is the equity or shares held by the state. Sources of state capital participation. The capital injected into Perseroan companies may originate from a variety of sources. The state budget, APBN, state-managed development projects, state receivables, capitalized reserves, or other means such as gains from asset revaluation. Post-investment asset management. Once the state's capital becomes equity, the management of Perseroan assets follows corporate law, not state finance law. For instance, Perseroan assets are not subject to the same procedures as state assets for actions such as asset write-offs or public sector accountability. Normative conflicts. Professor Khairandy identifies significant normative conflicts between Law No. 19 of 2003, Law No. 40 of 2007, the state finance law, and the anti-corruption law. In practice, this has led to confusion, especially in corruption cases where Perseroan assets are mistakenly treated as state assets. Profit orientation. The primary objective of a Perseroan is to generate profit. However, the government may assign Perseroan companies to deliver public services as long as such tasks are accompanied by compensation based on commercial principles. In broader functions, Perseroan companies are also expected to contribute to national economic development, act as pioneers in unattractive or high-risk sectors, provide high-quality goods and services to the public, and support small businesses and cooperatives. Summary, conclusion. To summarize, Professor Khairandy's research provides clear doctrinal guidance. Perseroan companies are private legal entities governed by private law. Their assets are wholly owned by the company, not the state. The state's interest is limited to its role as a shareholder. Emphatic. This distinction is crucial for accurate legal interpretation, sound corporate governance, and avoiding misapplication of laws, especially in financial auditing, policymaking, and criminal law enforcement. Thank you for your attention.